Okay, well, welcome to our webinar today. Thank you so much for joining us. My name is Ashley Purvitt. I'm the Executive Director of the JMU Alumni Association. I actually graduated from JMU with my master's about a year ago, so proud Duke here, and I'm excited to welcome all of you to our webinar today hosted by Evan Bolick, class of 2005, and the title for today's presentation is Online Defamation, What Can Be Done to Protect Your Good Reputation. Today's webinar is brought to you by the JMU Alumni Association, and we are excited to bring you this webinar program with the goal of providing career-related resources that help develop your professional self. We're really excited today to have Evan on the phone, but before I turn it over to him, I just have a few housekeeping notes. If you could just make sure that your microphones are muted, and then we do have two chat options for today. So if you have a question or if you have some technical difficulties, feel free to chat with me via the chat section, and if you'd like to send a question that Evan can get to at the end of the presentation, please use the Q&A feature, and I'll be sure to share those questions with Evan at the end. Feel free to tweet during the event. We'd love for you to be out there on social media talking about this. And if you would, just use our hashtag, which is hashtag JMUAA webinar. And then we will record this webinar, and it will be available in a couple of days, and we'll send an email out with the information of how to access that. So if you have to drop off, or if you'd like to listen to it again, you'll be able to access that in just a couple of days. It's my pleasure to introduce our webinar host today, Evan Bolick, who is a 2005 graduate of James Madison University. He received his law degree from the University of North Carolina School of Law, and he is a litigation and education law attorney for the Rose Law Group located in Scottsdale, Arizona. He has litigated cases before the Ninth Circuit Court of Appeals, Arizona District Court, and the Arizona Court of Appeals, in addition to marrying a fellow Duke and welcoming their son Ridley in 2012. Evan writes short stories and scripts. So take it away, Evan.
All right, thank you for that warm welcome and talking me up. You know, it's great. Class of 2005 doesn't seem that long ago, and yet I think about it, and it's been a decade. I also have to say that there's another potential future Duke here. I have a daughter, Madeline, who is 2 months old, so I didn't want to be accused of favoritism with my son there. Anyways, thanks for joining us today. As you'll see, we've got a picture here of Joan Jett, and, you know, she's pretty bold and brash in saying that she doesn't give a, well, you know what, about her bad reputation. But that's not really an approach that works well anymore, especially with the internet. And as you'll see, the internet and your reputation thereon is of the utmost importance to both businesses and individuals. A few studies that I'd love to share so you can appreciate the gravity of the situation with the internet is that a 2014 survey stated that 88% of consumers trust online reviews as much as personal recommendations. So essentially, all of the reviews that you see online on the multiple, endless stream of websites out there carry quite a bit of weight. It's, even though they're strangers posting, they're considered by most people as trustworthy and reputable, as if your best friend came over and told you about a business. A 2015 study said that 67% of customers are influenced by online reviews before they purchase a good. So again, well over half of people are looking at online reviews before purchasing services. And, you know, it's not just popular with restaurants and bars, which I suspect most of us use online reviews for, but there's also entire websites dedicated to reviewing doctors, professional tradesmen like HVAC and plumbers, babysitters, drivers, dog walkers, and virtually anything else you can think of. If it's a service, you can bet that some website is providing us with reviews. And that even goes for the legal business. It's small, but it's starting to grow there as well. Search results essentially act as a first impression for your business, and many people will never even walk into your business or give you a call or a tweet or anything like that, depending on what is said online. Not only that, but your personal reputation is at stake too. Career Builder reported from a Harris poll in 2014 that 43% of employers use social networking sites to research job candidates, which is up from 39% in 2013 and 36% in 2012. And that same poll showed that the 12% of employers that didn't currently research candidates online plan to start doing so. So we can probably guess that now about half of employers are looking up what is said about you online. Even more interesting is the fact that people make snap judgments very quickly. A 2015 study shows that individuals view less than 2%, that individuals view less than the top 5 results on the first page of an internet search. So basically, what's listed about you or your business in those top 5 internet search results, when you put your name in Google, that's what people are using to decide on. Not even necessarily clicking the link, just seeing how many stars there are and what's in the little snippet below the link. So, with all due respect to Joan Jett and her fans, we do care a lot about your good reputation. And what's a little frustrating is that the law, there's just not a lot of it yet that impacts the internet or applies directly to the internet. So as you'll see, we are still using laws that were written to address defamation in books and newspapers and magazines to try to address issues with online defamation, and it's not a great fit. But fortunately, by the end of this presentation, you should know what to be looking for as far as defamation goes, as well as what you might be able to do about it. And just to share an interesting story about how unfair online defamation can be and how ruinous it can be for your business, I always like to tell a story. There was a cafe in Vermont that had a sign advertising a bacon special, some sort of, I'm sure very delicious meal involving quite a bit of bacon, and a practicing Muslim complained, saying that she loved the cafe, but she didn't, eat bacon and didn't want that advertisement, and so the business decided to remove the advertisement for the bacon meal to be respectful of their customers' wishes. And what happened was a pretty legendary and still not too common attack by the online community, where they were so enraged they posted hundreds and hundreds of fake false reviews, all of which were negative, including people who had never been to the cafe and were upset, more for political reasons that a restaurant would kowtow to the beliefs of one of its customers and simply remove an advertisement. And that business said that they saw their revenues declined by up to 90% as a result of this concerted effort and attack on them. Eventually, the social media website stepped in and cleaned it up and essentially saved the business. But think to yourself, what would happen if you came under attack, you or your business? Could you afford to lose revenues of up to 90%? Could you afford to lose many job opportunities if there is someone maliciously defaming you online? So again, combined with those statistics, I do believe that this is a very important area of the law that's really important for you to understand your rights with. So with that, we will begin. And of course, the best place to begin is, what is defamation? Now, a lot of people just think that anything that is written negatively about you is defamatory, and that's not really true. There are 2 bodies of law to always check with. There is federal law, and then each state has its own set of laws. To kind of give you an idea of what I'm talking about, you may have heard that various states in Washington, D.C. have passed laws permitting the usage of marijuana in some form. But it's still legal to use marijuana because under federal law, which is a different thing than all of the state laws, it remains completely illegal. So if you're caught smoking marijuana in a state that permits it, chances are you would be hauled into federal court, not state court. And that applies for all law, criminal law, civil law, and in this case, defamation. So what you always want to do is check with your state, your specific state's laws for what options are open to you. Again, most defamation law is pretty similar across the states, but there are a very small handful that have started to broach the internet as far as defamation. We won't really be talking about federal law except to say that you do not have a First Amendment right to spread lies and defamation about other people or businesses. So don't try that argument. It's definitely not going to work. And the federal law also makes it a little difficult to get information you'll need if you file a defamation claim, as you'll see throughout the presentation. And this is just generally true that law very rarely makes anything easier for anybody. More importantly, though, as I discussed, every state has its own laws. This is just a general presentation, so if you have issues, you need to make sure to actually hire an attorney that looks at the laws in your state and how they apply. So what do I mean by defamation? Do I mean slander or do I mean libel? And the answer is really, I mean both of them. Slander and libel, they've both really been rolled into one claim for defamation. So in most states, you don't have to worry about what the difference is. All you need to do is say, oh, it's defamation. And even if the states treat them differently, typically there's no difference in how you would go after slander or libel. But since people always like to know, slander is when somebody says something untrue, and libel is when someone writes something that's untrue too, and both of them would be designed to impugn your reputation. Slander happens typically far less, except, ironically, on the campaign trail, where politicians make outrageous and untrue statements about each other all the time. There's a reason, and you'll find out as we go along, why politicians or any celebrities rarely sue for defamation. It's very, very difficult if you're considered a public persona. What we see more often in what this presentation is more geared towards is what was traditionally considered libel, which is written untrue statements that impugn your reputation. This is especially true in the internet era, where we can comment on almost every post, write on almost every blog, and generally maintain an online presence that's every bit as full of statements as what we talk about in everyday life. That said, slander certainly can happen on the internet too. I've had cases where I have had videos removed from YouTube for containing defamatory statements that would be traditionally considered slander. But again, don't really worry about the differences between the two. It's all pretty much rolled into defamation. So what is defamation? What exactly do I mean? Well, the courts kind of adopt an approach, which they do for a few things, which is I'll know it when I see it. A lot of people at home probably are shaking their head and saying, yeah, that sounds right. It's probably really obvious to know what's defamatory. But in reality, nothing it's very rare for something to be crystal clear. Take, for example, Donald Trump's recent comments about the Second Amendment supporters towards Hillary Clinton. Was that defamatory? Was it an offhand remark or a simple joke, or was it an actual call to action and a threat towards Hillary Clinton? I don't think that we'll ever know what exactly that meant or what it consisted of, and I think that's a good example of kind of the gray area that defamation is living in. But there are four basic principles. There's four things to look for, and we'll go through each of these coming up. But if each of these four things is true, then it's probably defamation. First, is it a statement of fact, not opinion? Second, is the statement untrue? Third, was the untrue statement made publicly? And fourth, is the statement designed to damage the reputation of the subject? If those four things exist, you very well may have been defamed. So let's look at some examples. Again, since we're going to take the approach of we'll know it when we see it, examples will be really important here. Some good purple and gold here. We've got someone, and I've made all of these up. You know, you can do a Google search, but none of these exist towards me in any event. We have UVA Manly Man, who says, Evan Bolick is just a simple JMU grad with only 6 years under his belt as an attorney. So, you know, the use of the word simple grad and suggesting 6 years of legal experience as a negative, I mean, this is clearly not a positive comment for me. It clearly doesn't make me look particularly good. And I would say this is probably intended to lower my reputation amongst prospective clients. But is it defamation? No, it's not, because if what is being said is true, it cannot be defamation, no matter how negative, how mean, how upsetting the statement may be. Truth is an absolute defense to defamation. Also, I'd like to say it doesn't hurt my reputation to be a royal duke. That's a statement of fact, not opinion. But yeah, I mean, if we look at this statement, it is true that I am a JMU graduate, and it is true that I have 6 years under my belt as an attorney. So I may not like the way that this is written, and I may not like what it's implying, but there's nothing I can do about it. And really, you know, this is as gray as areas may be, going after true statements is your worst bet. I had a client once who ran a landscaping business, and he hired us to sue a good chunk of his ex-employees who all made claims online that he didn't like about the business and how it treated its employees. And in the vast majority of these cases, the ex-employees provided documents showing that what they had said about the company was true. And in the end, the business got sued, and my client ended up having to pay out quite a bit of money to the ex-employees to get out of these lawsuits. So he had not been upfront with me. You know, he had sworn up and down all of these things were untrue, and he had promised to get me documentation, you know, proving it, and was absolutely unable to, and ended up costing himself quite a bit of money. So really, if there's one thing you take away, don't go after someone if what they are saying is demonstrably true. And another lesson, don't lie to your attorney. If the client had been upfront with us, we would not have let him file the lawsuit, and he would have saved quite a bit of pain and money. All right, so let's look at some more examples here. All right, so Snobby Dude 18 writes, EB's restaurant has got to serve the worst food in the history of the world. All right, so that's something that I actually see pretty commonly, some derivative of that on places like Yelp. You know, oh, this is just the absolute worst, most awful experience of my entire life. And then we've got one where we'll have a response. We've got this one, Wouldn't Like Me Mad, says, Evan Bolick didn't return my phone calls for 2 days. That is unacceptable. And I always love in comments when I'm looking through them when people put in random capitalization. And then Evan Bolick responded, actually, it was only 1 day, not 2. That is a reasonable amount of time to get back to you. So here we've got 2 comments. You know, let's look at that first one. The restaurant has got to serve the worst food in the history of the world. Now, probably that's almost, it would be hard to believe that that would be a true statement. You know, I'm sure Snobby Dude 18 hasn't been to every restaurant in the world, let alone every restaurant ever made in the world. And it's certainly negative, and it certainly wouldn't help my business for this to be out there. And the other one, we've got a person who who made a mistake or purposefully lied and said that I didn't call them for 2 days when it was actually only 1 day, and also is claiming that, you know, whatever amount of time it was unacceptable. So again, are these statements defamatory? I'm sure you've guessed because they're still early in the presentation. It is not defamatory. There are exceptions in defamation law for hyperbole, exaggeration, and minor errors. So with that first one, you know, nobody's really going to believe that literally my restaurant served the worst food ever created in the entire history of the world. It's clearly hyperbole, clearly an exaggeration. It may not really help my reputation, but it's so far beyond any sort of truth that courts wouldn't look at this and say, oh man, this is clearly defamatory, because it's simply so out of the realm of possibility that nobody reading that would really think that the statement itself is true. Certainly they'll get the impression my restaurant's not a good restaurant, but no one would think it's actually serving the worst food in the history of the world. And then there's minor error. Evan Bolick didn't return my phone call for 2 days, and I said it was 1 day. Well, courts really aren't going to be very open to a claim where I said, see, it was totally untrue. They said I didn't recall it for 2 days, and it was only 1 day passage of time. The fact is, I didn't return their call for some period of time, and 2 days is close enough to 1 day that even though it's untrue, even though it's negative, even though it hurts my reputation, it's too minor of an error for me to actually go forward with my claim. Minor error applies to a lot. Typically, if generally what's being said is true, then the courts are going to allow it no matter how far off the error is. You know, it would have to be something extreme, like say, you know, Evan has 1,000 health violations in his restaurant and it was only 1, then you're getting into out of the small error territory. But even if he said, you know, oh, Evan has had some health violations or multiple health violations at his restaurant and it's only 1, chances are court's not really going to be responsive. And now there's also this comment about my failure to return a phone call being unacceptable. And we'll address, and I'm saying that it is acceptable to call someone back in 1 or 2 days. So that kind of statement is actually going to be addressed on the next slide, which is starting now. All right, so let's look at another statement before, and both of them will fall under this. Chef Boy RD said, in my opinion, EB's restaurant serves the worst burgers ever, at least the worst I've ever eaten. So, you know, we're back into the hyperbole a little bit. But what we have here is the fact that statements of opinion are not defamatory. And I've made this one really easy. Right up front it says, in my opinion, EB's restaurant serves the worst burgers ever. So in order to be defamatory, it needs to be a fact. And why is that? It's because for defamation to exist, what is said needs to be untrue. And when it's an opinion, you can neither prove or disprove the truth of that. So even going back to that last comment where that person said it was unacceptable for me to call them back in 1 or 2 days, that is not a statement of fact. That's their opinion. That amount of time is unacceptable, and it was my opinion that it was reasonable, and neither of us can really disprove using facts or statistics or anything like that who is right. Or at least you probably can in a court of law, but it would cost quite a bit of money and involve a bunch of legal experts. So, so basically, whenever you see comments like I think or IMO, which stands for in my opinion, you probably are not dealing with defamation. And we've got another comment on this slide. Evan Bolick is such a jerk and a maggot. He forced me to read a book instead of going to the movies. That was from Teenagers Rule 13 through 18. So look, I've just been called a jerk and a maggot. That's not good. You know, I don't want a potential employer seeing something about me being a jerk and a maggot, and especially unfair since all I did was try to help this teenager gain some culture beyond movies. But again, insults and name-calling generally, not always, but the vast majority of the time are not defamatory. And you see a lot of this kind of stuff on the internet. You know, a lot of statements full of vitriol and downright vile and using words far worse than jerk and maggot. But these kind of fall, once again, into the area of opinion. You know, it's their opinion that I'm a jerk and a maggot. You know, and lots of people might think I'm a really nice guy and a hero for doing the book instead of a movie thing. Part of when name-calling can be actionable in a court of law is when it grows into something like cyberbullying. But again, that's a different set of laws that you'd be dealing with. It wouldn't really be defamation. All right, so I bet this statement, since it's already up and in the center of the page, probably is going to be defamatory, but let's read it. It says, Evie's restaurant served me undercooked shrimp and gave me food poisoning. When I complained to owner Evan Bolick, he tripped me and laughed as I fell to the ground. I am sure he'll treat future customers this way too. That was posted by Pants on Fire, and we always know why people's pants are on fire. All right, so let's do our little four-pronged test here. Are there factual statements? Well, that can be disproved. There definitely are. They're claiming that I served them undercooked shrimp. They're claiming that they got food poisoning. They're claiming that they were tripped by the owner, and that's
Evan, it sounds like we lost you a little bit. Can you hear us? Whoops. Sorry, everyone, we're having a little bit of technical difficulty, and we will get that resolved as quickly as possible.
Hello?
Yes, you're back on.
Okay, great.
Great.
Sorry
Thanks, everyone,
about that,
for hanging on.
Yep, how the internet. All right, so I'm sure you've had time to read the comment. So to speed things up, I had been discussing that there are factual statements made throughout this comment that they're claiming that the food was undercooked, that there was food poisoning, that they were tripped, and that they were laughed at. So these are all things I can, in fact, prove or disprove. The next one of our test is it demonstrably untrue, because remember, truthful statements are never defamatory. So, you know, I could give the logs from my restaurant showing how the food was cooked, how long the food was cooked, the temperatures of the foods that were cooked. You know, I could pull hospital records in litigation showing whether or not they did have food poisoning, and if so, when, and also figure out what else that person ate, and possibly that's what gave them food poisoning if they did have it. I could certainly use both witnesses as well as any video camera footage to show them that they were not tripped and that nobody laughed them as they fell to the ground. So there are plenty of ways to prove or disprove the statements that this pants on fire made. Third, this was published online. You know, that's something that's always important, but we don't dwell too much on. But for defamation to occur, it needs to occur publicly, because that's the only way for your reputation to be tarnished, is for the public to hear it. This being posted online, it certainly was published publicly. And then finally, does it damage my personal and business reputation? Because you're going to want damages. You always want to be able to show that this caused something to hurt you, because otherwise, what's the point of going to court? Some states will let you, if you prove defamation, they'll just give you a preset amount as damages, but that amount is usually pretty low. So, you know, I would want to show that after this review, people stopped coming to the business, or I started getting more negative reviews, or something of that effect. Or maybe somebody stopped doing business with me because of this. But in any event, this is a great candidate, this type of complaint about what is defamation and what kind of statements to look for here. There are a few other considerations for defamation. There is the press exemption. It's really nice to, the press is specifically set forth in the First Amendment as having a right to the press, and that is the absolute hardest type of thing to sue for defamation, is the press. Reporters are allowed to quote defamatory statements, and media companies are allowed to publish defamatory statements unless they absolutely knew that the statement they were quoting or publishing is false and defamatory. And it's really hard to prove what they did or didn't know was false and defamatory, especially when they can keep their sources shrouded in secrecy and have a lot of experience in skirting that line between opinion and fact, hyperbole and defamation. And finally, if anybody's going to fight a lawsuit, it's going to be the press over defamation. So be ready for a long litigation if you're going to actually try to sue a reporter or any sort of publisher. Public figures have a much more difficult time suing for defamation successfully than private figures. Now, what is a public figure? Certainly it's anything like an athlete or a celebrity or a politician, but more or less, a public figure is anybody who is publicly, or any entity that is publicly renowned, that's publicly out there with a stage that people listen to. Whereas a private person is someone, you know, who kind of does a 9-to-5 job and goes home. You can also be thrust into the public forum unwillingly. For example, if you're in a high-profile case, like the O.J. Simpson case, probably not many people knew those attorneys before the O.J. Simpson case, but they certainly knew who they were afterwards, at least as it regarded to the Simpson trial. So for at least purposes of the Simpson trial, they were probably considered public figures. It's getting harder and harder to figure out what a public figure is because of social media, because now almost everybody, even that person clocking in 9 to 5 and going home, has social media, and they're out there amongst dozens, hundreds, thousands of people who follow them on these social media pages. So Does that mean they're no longer a private figure, or does that mean they're a public figure? Each state has pretty much its own answer, and a lot of states don't have any answer yet, but it's something to be aware of, that you may, soon everybody may be considered a public person. And the reason why that's no good is that public people have to prove what's called actual malice. And this is why you don't see celebrities or politicians or athletes sued too often. I mean, with a standard like called actual malice, chances are that's a pretty tough standard to beat. And again, it is. It means that you have to show that the person who made the defamatory statement either knew for sure it was untrue, or that they knew or that they acted with reckless disregard for whether it was true or not. So it's very difficult to prove what a person did or didn't know, or show that they acted with reckless disregard. So if you're a public figure, and it's also arguable whether businesses like restaurants are public figures, since they're catering to the public and have public websites, and oftentimes public social media pages, a lot of times they are considered public figures. So you have to keep that in the back of your mind. There are retraction requests. Some states require that you ask the person to remove their comment before you sue them. And then there's always countersuits, and this kind of goes back to that example I was giving you of the client who accused a bunch of his ex-employees for defamation. You've got to be careful that they don't sue you back, because once once a counter lawsuit is brought against you, the cost of litigation goes up exponentially. And then I threw at the bottom one more time to drive it home: the truth shall set you free. Don't go after anybody who is telling the truth. All right, so now that we know what defamation is and possible defenses to defamation, what in the world do we do when you've been defamed? All right, step one is looking for your statute of limitations. Most people outside of the legal world don't know what a statute of limitation is, but there's essentially a time limit imposed on every crime and every lawsuit, where you either have to be prosecuted for that crime or file your lawsuit within that time, or else you're blocked from doing it. This was a decision made because we don't want people to forever be subject to a lawsuit or criminal action at any point in time in their life, you know, for anything they've done in their history. For example, if Aladdin steals bread at age 15 when he is no more than a street rat, we don't want to throw him in jail when he's 35-year-old king 20 years later. You know, at some point you have to just have gotten away with it, more or less. The unfortunate thing is that, again, we are using old law that doesn't really apply very well to the internet. As you'll see here, Arizona, Virginia, and Maryland each have a 1-year statute of limitation from the date of publication. So from the day that the defamatory statement is posted, you have 1 year to sue about it. This made a lot of sense when it was books and magazines and newspapers, because not too many people read those sort of things a year after they've been published. But with the internet, defamation occurs almost any time you Google or otherwise search for your name. I don't know if Bing is a verb yet, but Google or Bing your name, and suddenly that defamatory post from 5 years ago is always going to be there. And it's not even difficult to find it. It's not like you have to search through microfilm or go to the library. You just click on your computer. So that's why it's important to be vigilant, because you know, there are still things you can do to try to get around the statute of limitation, but it's very difficult and you've got a very short period of time. Some states may also slow the countdown, but you'll need to look at, you know, again, you'll need to look at your actual state law to see whether that exists, and if so, how and what the circumstances are. For example, a lot of states, if a defamatory statement was published in a website that was password protected to access, you needed to put in a password, then typically they'll start the clock once you got the password to enter the site and discover it. But that's one of a few types of exceptions here. Also, ISPs could make this time even shorter. And what is an ISP? ISP stands for Internet Service Provider. It's like Verizon or Cox or any other place that you get your internet from. Whenever we use the internet, we have something called an IP address, which is basically our name online. It's a bunch of numbers, and they belong to you whenever you use your computer or any other computer. The IP address is associated with that computer. But all we can get is this bunch of numbers. It's the ISPs, the Internet Service Providers, that know who belongs to that number. So when you get into a defamation suit, you need to be able to go to the ISP and ask them, hey, who used this number, who used this IP address to post this comment? Because eventually you need to find the person who posted the comment. And typically, they don't use their real name online. They use some sort of screening. The problem here is that a lot of ISPs are getting really annoyed at having to answer these requests for information about IP addresses. So they are starting to keep their data for a less and less amount of time. Some ISPs only keep the data of who owned what IP address for 6 months. So really, step one when you are engaging in this is to send a letter to the ISP saying, hey, don't delete anything relating to this IP address. And don't worry, your attorney should help you, or a computer guy should be able to help you, or girl should be able to help you find the IP address and the ISP it belongs to. But you want to get a letter to them as soon as possible, so that way, even if you're in that 1-year statute of limitations, the ISP doesn't delete the information you need to identify the person who defamed you. Another good question is, where do you bring the lawsuit? In theory, you can bring a lawsuit anywhere in the United States. Typically, lawsuits need to be filed where the incident occurred. And with the internet, technically, the incident occurs anywhere you can read that post. That said, you commonly, if you live in, Virginia, you don't want to file your lawsuit in Hawaii, because that means you'd have to fly to court in Hawaii, and that's not really too convenient. What you do typically want it, what you can do, and I get to handle cases from across the country thanks to this, one of the things you can do is you can file it where the defendant or the plaintiff lives or resides. So if you have a good idea as to who posted it and where they live generally, you might want to bring it there, or you can just bring it where you live. And yeah, this is the step where it helps me to be able to practice all over the place, is that there are companies that own all these websites. What you do typically when you get a website is you pay a company for the website name and the website, and they do what's called hosting it. GoDaddy is probably one of the biggest website hosts, and they are located in Arizona. So plenty of times people choose to file in Arizona because that's technically where something occurred. When you posted something to a website and the host of the website is located in Arizona, then theoretically it occurred in Arizona. Or you can go where the ISP is located, because chances are the defendant is located somewhere close to where their ISP is located, since that ISP is giving them their internet. Finally, if it's a foreign website, and I've had this come up a few times, unfortunately you're a bit out of luck. It's really difficult to locate a person or entity abroad. It's not impossible, but it's very difficult, and it's also really hard to drag them into a U.S. court. I haven't had a client yet agree to pay to fly me to Europe or Asia, where we've had a few people discover they've been defamed. But you never know. I can always cross my fingers and hope someday that gets to happen. All right, so assuming that you are within your statute of limitations period and you filed your lawsuit in the proper place, what's next? And there's one truism of litigation, which means going to court. And that truism is it's very expensive. But fortunately, when you file a lawsuit, you don't necessarily have to go all the way. And I typically don't recommend going all the way to the end, especially for defamation. And here's why. Here's a few places I've put down exit points where you can try to get out of litigation before going all the way to trial, but still achieve your goals. So, of course, first you have to file a lawsuit against the individual or entity that authored the claim. Now, I'm not aware of any states that let you sue an anonymous person or a screen name, but you can start out that way. And so you file the lawsuit typically against a John Doe or a Jane Doe, and then you use the court's powers to subpoena documents, to get documents from ISPs, from Google, from Microsoft, to find who that person behind the screen name is, or who that entity behind the screen name is. And then once you figure out who it is, you can change it from Jane Doe or John Doe to the actual person who you are suing. And then what you have to do is, once you know who is your defendant, you serve them with a copy of the lawsuit. And this is what I call exit point one. And this is exit point one, I'd say, is utilized 90 or 95% of the time. Because typically what you want with defamation is to get this off of the internet. You don't really care that much about suing someone for damages, because especially for things like Yelp reviews, there's not a lot of damages to be had, but you want it down. And so most people, fortunately, that aligns with what most people want, is not to be sued. They don't want to go to court. They don't want to hire a lawyer. As expensive as trial is for you, it's expensive for them as well. So what we typically do is, once you have given the individual or entity the lawsuit, you ask them, hey, will you agree to remove this post or the multiple posts, and in exchange, I will drop the lawsuit? Or if they can't remove the post, you can say, hey, will you agree to help me get this de-indexed, which is something we'll discuss a little later. And if so, we won't record the lawsuit against you. When you win a lawsuit, you get a judgment. And typically you do what's called recording a judgment. You file it so that anytime someone looks, it goes up on their credit report. But if you don't record it, it doesn't go on their credit report. So that is another option. So that's exit point one. And as I said, it works the vast majority of the time because most people don't want to go through a lawsuit, and it's really no skin off their back to take down a comment, especially one that's untrue and defamatory. Another good thing about that is, in a settlement agreement, you can put in what's called a non-disparagement clause, you can put in a term that they don't post that comment again anywhere else. And this is great because now you have a contract, and it's far easier to sue on a contract than it is to sue on defamation. So if they defame you again or repost the comment, suddenly you've got a much stronger case. You already know who it is who has defamed you for the most part, and you'll have a lot more time than 1 year to sue them. But assuming that they decide not to settle, what you do next is you engage in discovery, where you subpoena records, you depose the person who defamed you or entity, you determine the amount of damages, and then you do what's called a motion.
Sorry, everybody. It looks like Evan has dropped off again. We're going to get that resolved as quickly as possible.
So unconnected.
Evan, it sounds like you're back on. Are you on?
Hello?
We can hear you.
Oh, great. Okay.
Thank you.
Sorry about that. I can hear you guys. I'm not sure why I keep dropping out, so my apologies. But in any event, the second exit point is a motion for summary judgment. You've got all the evidence, and then a court will, from there, be able to make a decision as to who, assuming that the evidence overwhelmingly supports one side or the other, they can make a decision right there and then as to whether it's defamatory or not. And that happens a lot in defamation, since it's usually pretty cut and dry if somebody lied and made a defamatory statement. But if you lose that, then you've got to go to trial. And that's where, you know, you've seen Law and Order. It's similar to that, not quite as dramatic. But, you know, there's witnesses and testimony and evidence and judge or a jury. And if you get a judgment at the end of the day, then you can go about and try to get the defamatory statement removed. One thing I did want to focus on is, again, because most people don't use their real names, they use anonymous names, and I discussed this a bit on the last slide, is that you need to find out who that person or entity is that made the comment. So first, as we had stated, you file a complaint against John and Jane Doe. If required, if your state requires, you have to post a public notice, usually a comment to a comment or comment to the post or some sort of email if there's an email, where you give this anonymous person notice that you filed a lawsuit against them. And I have never seen anyone respond to that sort of public notice, but some states require you do that. You want to figure out how much time you have to serve the anonymous speaker. And again, because ISPs often delete their information after 6 months to a year, you know, if you're getting close to 6 months or a year after that comment, then you really want to hurry to try to figure out what the IP address is in order to ask the ISP who used that IP address. How do you get the IP address? You usually, so most people post things on Google or Microsoft-owned websites like YouTube or Google Circles or something like that. So what you do is you, you know, even better is when you click on the screen name, it'll usually take you to an email address, and 9 times out of 10, it's at Outlook.com, which is Microsoft, or at Gmail.com, which is Google. So you'll send a subpoena to Google or Microsoft or whomever owns the email address, and you'll say, amongst other things, you'll ask for the name of the person and their address and anything else that they have, but you always need to ask for that IP address, and they'll give it to you. And once you have the IP address, there's places online you can go and look up the IP address and figure out who the ISP is. So that's it in a nutshell. Also, they will typically notify the person who does own the account that posted the comment that they are answering a subpoena, and sometimes when they see that things are getting serious, they'll reach out to me and let me know who they are and that they like to deal. So that's great. Now, when you go to an ISP, you also need to obtain a court order to do so, and I cited the federal law that requires that. So that's another step. Again, you've got to be pretty quick, unfortunately, about defamation. Once you know who it is, again, that's when you reach out. That's when I reach out, you know, and you can do whatever your attorney advises. But that's when I reach out and I say, hey, let's try to settle this. Why don't you remove it? and we'll be done here. You know, we'll let go of that lawsuit, and then you've both gotten what you've wanted, and you haven't dropped a ton of money. Anyways, if you have to go all the way to the ISP, they definitely have to give notice to the customer, and I'd say that's the point where I typically find out who it is and am able to make a settlement deal with them. And again, oftentimes I'll also hear from their attorneys, and a lot of times the attorneys will say, well, we want the identity of that person who posted this to remain secret, to remain anonymous. And typically that's fine with me because, again, our goal is to get them to remove this. So what I'll say is, fine, we'll do a settlement agreement and we'll agree to keep the signatures to the agreement that would show the name of the person who defamed you. We'll keep it confidential and secret, but unless this comment is reposted, in which case then we get to look at the signatures and figure out who it is. All right, so after the judgment, so let's say we've gone through and we've either settled the case or we've won at summary judgment, or we go to trial and we win there. What now? What now? So the bad news first, and don't yell, I haven't wasted your time, but a lot of people are surprised. No law requires a website to remove defamatory material. So, in any event, so you're going to say, Evan, what in the world? We can't even get rid of this stuff. You know, if the person's not willing to take it down and the website doesn't have to, well, what's going to happen? Well, here's the good news. Most reputable websites voluntarily remove illicit content such as defamatory statements. So, you know, at the bottom of every website, there should be, and if you own a website, you should make sure, things called privacy policies and terms of use, or terms and conditions. And in there, they talk about all the reasons they will remove something. And almost every reputable website voluntarily, in their terms and conditions or privacy policy, will remove defamatory statements. So that's great, and they're beholden to that. They can't just pick and choose. If they say they're going to do it, they legally have to do it. And then Google and Microsoft do what's called de-indexing. So the way search engines work is that they don't search per se in real time through every website in the world. What they do is they're constantly scanning websites, and they create what's called an index, where they know what's on each website as of the day it was scanned. This is why when you change a website, occasionally it takes a few days for Google or Bing to update what the website looks like when you click on it. Or you'll see something called an archived web page, which means that you can still access an old website through what Google and Bing still have on their index. So when we say that they de-index something, that means they remove it from the index, which means no matter what you put into your search, you cannot pull it up on Google or Microsoft because it will not be in their index anymore. So that's almost as good as removing it from the website itself, because very few people go to a website and then search for your name or your company unless it's a place like Yelp, which will remove it voluntarily. So even if you can't get the website to remove it and you can't get the user to remove it, you can get Google and Microsoft to de-index it, and thus it doesn't become searchable. And that's how most, especially employers, look for stuff. I've included the language here. You can see from Yelp where they agree right here not to maintain defamatory reviews. All right. So there are also some non-litigation methods you can look at, non-going to court methods, where you can look to see if you can get rid of defamatory material. First is to directly just contact the website it's posted on and ask if they'll remove it. chances are they won't, but you know what? It happens more than I expect. It's still probably only 10 or 15% of the time, but you know, it does happen. There are companies out there, they market themselves, they're reputation companies. I say they're a bad method, and this is my opinion, just in case anybody out there works for a reputation company and, and thinks this is defamatory. But I have seen a few reputable ones, but mostly, again, as I just stated, there's nothing that forces a website to remove defamatory material or for Google and Bing to de-index defamatory material until you have a court judgment. I mean, you can't get a court judgment without suing anybody, without suing someone. And again, this is why I go back to settlement too, because then you don't even need a court judgment. You just have the user take down what they've posted. So that's really your best bet, because it's completely gone and you don't have to cross your fingers about what's stated in the terms and conditions. But if they won't take it down, then you do need that court judgment, or if they can't take it down. And reputation companies typically can't do that because they can't get judgments. What they typically do, a lot of the methodology they used to use isn't effective anymore because Google and Bing figured out what they were doing and didn't like it, so they've changed their search algorithms to get around a lot of the things reputation companies used to do. And other things they'll do is they will negotiate with the website for you to pay the website to remove it. This typically happens with really disreputable sites where this is where they make their major money by you paying them to take it down. And there have been reports out there that Yelp is starting to get into that business of not necessarily removing things for money, but making things more or less prominent for money. And so reputation companies, a lot of the time, what they'll do is they'll negotiate a deal for you to pay to get it removed or lowered or something like that. And I also don't like that because I've heard many a horror story where they've paid quite a bit of money, and then a year later, that website will say, we're going to repost it now unless you pay us another X amount. So if you do ever pay anyone to remove a website, make sure you have it in writing that it will be removed permanently, forever, because you definitely don't want to have it being held over your head for years. You can always file a response to, almost always file a response to any sort of comment made online. My only suggestions for if you make a response, first wait 24 hours, because a lot of times responses can do more damage than good. And secondly, have someone else read it over. You want to look really professional, especially if the person making defamatory claims looks crazy, you know, using the random caps or using a lot of bad words and stuff. If you respond in kind, that actually makes them seem right and accurate. You want a professional response, properly spelled, properly worded, and making sure that it's saying what you mean it to say. The last thing you want to do is post something that can be read a completely wrong way. So always have someone read it over and wait 24 hours. And you can go to the Better Business Bureau. This is more for individuals, you know, if a company has defamed them, which certainly does happen. Sometimes I've seen companies go online and talk about how bad a person is, a customer that, or a client that they had. And they don't have power over companies, but they can help you try to negotiate some sort of settlement. Plus, Better Business Bureau is a really respected website, so, you know, complaints there are taken more seriously and vetted pretty well. Beware of websites like Ripoff Report. They don't let you remove or edit postings. This is becoming more in vogue, where basically in those terms and conditions I was telling you about, or terms of use that nobody reads, it says that they own your post and that they control your post once you've made it. You even need to get permission to edit. This happens in a lot of my cases where even if the user does want to get rid of the post, they cannot do it because they don't have access to their own post anymore. And that's why de-indexing is such an important tool, because even if I can't get the user to remove it and I can't get the website, because trust me, if they own that post, they want money in order to remove it. They're not going to do it for free just because defamation, then we can just go around them by going through Google and Microsoft and getting it de-indexed. But be careful where you're posting things. I'll tell you one other interesting story. This was a couple that had filed for divorce. The husband went on to Rip Off Report and said all sorts of untrue, nasty things about his wife, and then they patched things up, and he couldn't remove the posts. Needless to say, that did not help their reconciliation, and fortunately we were able to get it de-indexed, but it was, it was something he very much regretted. And then, of course, copyright. This is great. The best thing you can hope for, really, in a defamation case is that they put on something that you have copyrighted. What can be copyrighted? Almost anything. Photographs, videos, drawings, stories, menus, lots of stuff can be copyrighted. Computer programs, as long as it can be seen or perceived in some sort of physical medium. So let's say someone put up a defamatory comment with a picture of you from your website that you own. That's your picture. So although no website is required to remove defamatory content, the law requires that if the website is using copyrighted materials without permission, then you need to be shut down, that they need to get rid of that copyrighted material, or you could actually shut the website down. So you better believe that websites, even if they're not too sympathetic towards a defamation claim, they are very attentive to a copyright claim. Copywriting materials, now, and you own a copyright, by the way, as soon as you make something. So when I click on my camera phone a picture, I own a copyright to that picture. When I write, a letter on a screen, I own that. What you need to do in order to use copyright for you, though, is you need to register the thing with the Copyright Office. It's a pretty quick and easy relatively.
Evan, it sounds like you're cutting in and out here.
All registering it does, it gives notice that you do, in fact, own the thing. Okay.
Evan, you're cutting out, and I see we're on the last slide, and I know Evan has a final slide which will share his information, and I'll be sure to send that out. It has been an awesome presentation with a ton of great information for those of you who are interested in learning how to protect your online reputation. I want to make sure that if you have a question for Evan, he does have actually, I will send out his email address in the wrap-up so that if you have a question about the presentation, to feel free to direct that to him. But Evan, it sounds like you might be back on again.
Oh, good.
Okay, good.
Sorry about that, guys. And you are
okay.
I am on my last slide. I don't know why I can continue to hear you. But yeah, just to cap it off here, again, if you have copyright, it becomes much easier to get something down. You just need to be able to prove ownership of the copyright, meaning you need to have the original in your possession. So be careful when you take pictures or something on your phone and upload it to like Facebook or something, because Facebook does not have data showing that it's an original picture. Only your phone does. So you always want to keep copies of originals around, just so you can say, hey, there's no doubt that this is mine. You can do it with a Facebook picture. It's just a lot harder if it doesn't have this data it needs. So again, at the end of the day, there are things you can do to help combat online defamation. De-indexing is very powerful. certainly removing it from a reputable website based on their terms and conditions, and of course, negotiating an agreement with the user is very helpful as well. Again, I'm happy to discuss any questions, or certainly if you have a need for any services, either I can possibly help you or recommend you to someone who can. And of course, if you mention this presentation, we'll give you a 10% off the legal services, which is pretty great in my opinion.
Well, thanks so much, Evan. We really do appreciate your time today, and thank you to all of our attendees who've spent time with us learning about this important topic. It sounds like lots of interesting things and lots of challenges given today's focus on the internet and social media. So thanks so much for enlightening us, Evan. And again, if you have questions, feel free to reach out to Evan directly. You'll see an email from me later today with information about a survey, and we'd love for you to take a few minutes just to fill that out to give us some feedback about today's program, but also the webinar series in general. Thanks so much, and have a great day. Go Dukes.